Should I go first? Thank you, Commissioner Lander and members of the committee. My name is Dan Ackman. I'm a lawyer in private practice, and I've litigated on behalf of taxi drivers, often against the TLC. But I'd like to talk today about an issue that's been discussed at this meeting, which is overcharges of taxi drivers, which I've also litigated about unsuccessfully. And because of that lack of success, I think it's very important that the TLC become further involved in this issue. We've heard that there have been some efforts made, and I congratulate the TLC in the past for doing it. And I can say that Meera Joshi, I've met with Ms. Joshi in the past about this, and actually she arranged for an affidavit to be filed by the commissioner in a litigation, which sad to say did not carry the day. But what has happened, our case is involved, or on behalf of drivers who've been overcharged by their managing agents. Now, the managing agents have a role. They're not the fleets, but about half the industry is now what we call a DOV driver, or a driver-operated vehicle, where the driver owns the vehicle and leases the medallion. And the leasing agent leases the medallion to the driver, not the car, which the driver owns. But that gives the driver more of a stake, and he leases it by the week rather than by the day. So he tends to be a more steady driver, which is, as Ms. Joshi said, all to the good for the industry and for the public as a whole. But what has happened is there's been pervasive overcharging of drivers in the DOV system. We litigated against four companies. We basically lost because the court said these cases could only be brought in the TLC court, not in the General Supreme Court. And so we were out of court. But of course, a driver cannot bring a case in the TLC court. A driver can only complain, and the TLC can bring a case. And we've heard that they're waiting for more complaints, and that's in a way fair enough. But I don't think they need to wait, because the DOV companies are required. Actually, all companies, including fleets, are required to give drivers a written contract stating the terms of the lease, whether it's by the day or in this case by the week. Some of them don't even do that. They refuse to give a contract. And that is a blatant violation of the TLC rules, which the TLC can easily resolve by just demanding that each leasing company, and there's only about 25 of them, only about 10 are significant in size, simply demand, let us see your contracts. And in the contracts themselves, we found that there were all these added charges that were not on their face overcharged. They still charged the top amount for the lease itself, but they added charges such as vehicle management charges or anything they can name, which would add to the charge without clearly overriding the lease cap, but in fact that's exactly what they were doing. And I would suggest that the committee asked the TLC to demand the contracts. And also, actually, when Chairman Yaski was on the council, he advocated having a uniform contract that every company had to abide by. And I think that would be a great step, because then we would be very clear what is charged and what is not allowed to be charged. In the contracts today, the TLC rules actually require that each charge be authorized by a particular rule. And none of the contracts do that. But again, we could not successfully litigate this in the Supreme Court, so it's up to the TLC, and I hope they will do that. And also, actually, I think the TLC should also encourage the allowance of a private right of action, so there can be private litigation. Right now, the rules are silent on that, and it was deemed to be implied that there is no right of action in general courts. But I think that would be a good reform as well.
And I would also speak with Chair Rodriguez that a private right of action may be something that would be appropriate for legislation if it should be established, so we can follow up with you and with the TLC and explore.
Thank you
Very much for this.